Alright, now we continue our discussions with the other grounds of ultra bias under extended or implied ultra bias. Under extended ultra bias, there are four other grounds, sub-grounds, under retrospective effects, exclusion or ouster clause. Third is financial levy, and fourth is unreasonableness. Right, first let's discuss on the grounds of retrospective effect. There is a general rule stating that a subsidiary legislation made to operate retrospectively without express or implied authority by the parent act are not valid. In other words, when it operates retrospectively, means that it has backdated effects. So this is the general rule. Okay, so we can interpret that according to the general rule. Okay, if the public authority made subsidiary legislations that have backdated effects, so the subsidiary legislation will be considered as void. However, based on Section 20 of the Interpretation Acts 1948 and 1967, subsidiary legislation may be made to operate retrospectively to any date which is not earlier than the commencement of the Act or other written law under which it is made. So there is one exception here under Section 20 that it allows the public authority to make a subsidiary legislation that have a backdated effect, provided that it is not earlier than the commencement of the act. Okay, act here referring to the parent act that granted the power to the public authority to make certain subsidiary legislations. Okay, for example, the year of commencement of the parent act is 2015. Okay, and then later in 2020, okay, there was a subsidiary legislation made under the parent act just now. Okay, and it want to operate retrospectively, meaning that before the year of the regulation was made, meaning before year 2020. For example, let's say they want to have backdated effects, which the regulation maybe start operating on 2018. So it has backdated effect, but it's not earlier than the commencement of the parent act just now. The year of the commencement of the parent act is 2015, but the regulation has backdated effects because they want to operate it 2018. So no problems. Okay, the regulation will be valid. But what if they want to operate it retrospectively 2014, which is earlier than the commencement of the parent act, then the subsidiary legislation is considered as void. Okay, I hope that you get the example. Okay, the case there are so many cases too. Okay, under retrospective effect, but we can choose this case. So because this case is clear. According to the case of Attorney General against Cold Storage Singapura Private Limited, 1979. In this case, we identified the Parent Act, Port of Singapore Authority Act 1964, and then subsidiary legislation in this case is Singapore Port Local Authority Property Tax Order 1977. Right, brief fact of the case, this order, subsidiary legislation, was assumed to be enforceable from 20th October 1976. Okay, tengok. it has backdated effect because the order was made in 1977, but they want to operate it backdated effect to has a backdated effect 1976, earlier than the order was made. Hence, it was challenged on the grounds that it was retrospective. Yes, it was retrospective, but whether the subsidiary legislation is valid. Okay, refer to the court held in this case, the order was made under Section 28, Subsection 2 of the Port Singapore Authority Act, which gave the minister power to make orders having retrospective effect. Then we go to the roots of the case that the minister in the statute, in the given statute parent act, he has power to make orders having retrospective effect. So kalau ada retrospective effect sekalipun, the order is still valid. Okay. Okay, the next grounds of extended ultra bias is under exclusions of courts clause, or sometimes we call it as ouster clause. Okay, this is where the subsidiary legislation passed by the public body must not exclude the courts from making any judicial review. Okay, this is where they made subsidiary legislation, but they put a clause there which they not allowed they are not allowed any party to have to be to bring the case to the court in future. Okay, meaning to say that they want to prohibit any party to take any legal actions in future. So subsidiary legislation must not contain any provisions which does not allow any interference from the court unless if the parent act allows to do so. So the rule is, okay, the public authority is not allowed to make any ouster clause in the subsidiary legislation unless the parent act allows to do so. For example, as you can see in a case of Commissioner of Customs and Excise against Cure and Dili Limited, 1962. In this case, the subsidiary legislation has excluded the court from reviewing the decision made by the Commissioner of Customs and Excise. So in this case, they have put the ouster clause in the subsidiary legislation. So what is the status of the subsidiary legislation? According to the court, it held that the subsidiary legislation was void because it refused an individual's right to make an appeal to the court, and this was against the Parent Act. In the Parents Act, the public body have not given any power to make ouster clause. So when they exclude the court from reviewing the decision made by them, meaning to say that the legislation itself was void. Okay. Right. Next, the third grounds under extended ultra bias is a financial levy. When the public body impose a financial levy or tax without express parliamentary authorizations, and the court must determine whether the charge imposed by the public body is actually financial levy or not. This is the crucial matters that you need to determine whether the charge, okay, whether the fees, okay, considered as levy or not. So basically, they have no rights to impose any levy, okay, without express parliamentary authorization. In other words, without any power conferred by the Parent Act. Okay, as for example, in a case of AG against Wilkes United Dairies, 1922, based on the order made by the food controller, in this case, the appellants in this case were ordered to pay the controller a levy per gallon of milk purchased. So every time they purchase a milk, they must pay a levy, okay, to the food controller. So the court held that the levy imposed was not valid in this case because there was no express provision in the Parent Act which allowed such a levy to be charged. So public body, when they draft subsidiary legislation, they cannot include the levy. They cannot impose levy unless they have power to do so. Okay, but if it goes along, if it goes along with the purpose of the Parent Act, when they have power given by the Parent Act, so their action considered as valid. Okay, and the last but not least, under the grounds of extended ultra bias is the grounds of unreasonableness. When we talk about unreasonableness, these grounds link us uh, with the with the subsidiary legislation made by the public authority can be considered as unreasonable. So when it is considered as unreasonable, then it can be challenged in court. So what considered as unreasonable? You may refer to a case of Cruz against Johnson's, where this case provides us guidelines to determine unreasonableness. For example, sometimes the facts of being unreasonableness when the power, when they exercise the functions, okay, to the public disadvantage, okay, when it manifestly unjust, when the legislation disclosed in bad faith, involved such oppressive power or gratuitous interference with the rights. These are considered as unreasonableness. Okay? For example, in a case of Allied against Islington Corporations, the case involved a regulations which provided that all landlords of lodging houses must clean their lodging houses in the months of April, May and June each year. And the bylaw was challenged on the grounds it caused the landlord to breach their contractual obligations with their tenants. So we need to determine whether this bylaw is valid or not. And the court held that it was unreasonable and invalid because it prejudiced or unjust, okay, to the contractual obligations of the between the landlord and the tenants. Okay, they have the tenants in their house, but why they need to clean the lodging houses in months of April, May and June. Okay, so sometimes it will be called as ridiculous legislations, okay, or by law. Okay, other than that, when we discuss the issue of unreasonableness, sometimes we can consider unreasonable subsidiary legislations as against the fundamental principles. For example, when it against the Article 8 of federal constitutions. Okay, for example, as you can see later, okay, in your manual, in the case of Air India against Nagraj Mirza All India Report, in this case, the Air India, okay, being a statutory body, passed a rule that any air hostess would be required to retire on their first pregnancy after marriage. So this rule is totally unreasonable because it violates Article 14, the Equality Clause of Indian constitutions. And this is also applied in Malaysia. When you see that the legislations, the rules, the regulations made by this public body unjust, okay, or made in bad faith, then you can challenge it under the grounds of unreasonableness. Okay, before we end our discussions, okay, we need to determine the second grounds, okay, the main grounds of procedural ultra bias. When we talk about procedural, meaning that there was there must be a requirements of procedures, okay, or laid down in the Parent Act. Okay, procedural ultra bias means non-compliance with express mandatory procedures, then it will be grounds for procedural ultra bias. In other words, you can still challenge the public body if they fail to follow the procedure. Okay, examples of mandatory procedure. Normally, it depends on the Parent Act. Okay, for example, when they need to consult with a specified body, they must give opportunity for affected persons to file for objections and pre-publications of draft rules. Okay, for example, there are some procedures laid down by the Parent Act, but it depends on the Parent Act itself, okay, that confer power to the public authority. For example, some procedures, legislative control, when it requires the subsidiary legislation made to be laid before the legislature, meaning they have to be presented in the parliament, and then subsidiary legislation cease to have effect unless within the prescribed period the legislature pass a resolution affirming it, or maybe they must consult with a certain body. So the effect ignore general statutory provision to make a prior consultation as a formal requirement for the making of subsidiary legislations, but it depends on the acts. Okay, because some Parents Act makes it mandatory. And this is also similar with the publications, okay, whereby certain Parents Act requires the subsidiary legislation to be published in the Gazette, okay, and so on. Alright, and next, you need to differentiate the effects if the public body breach of a mandatory procedure and directory procedure. If that is only mandatory procedure, so it must be observed by the public body or administrator in making the subsidiary legislation. If not, the subsidiary legislation is invalid and unenforceable, meaning that, okay, if they have to follow certain procedures laid down by the Parent Act but they fail to follow it when they drafting the legislations, then the subsidiary legislation is considered as void. And if it is directory procedure, the public body or administrator need not follow the procedure. So they can choose either to follow or not the procedure. Non-compliance with the procedure will not make the subsidiary legislation invalid. In other words, if there is only breach of directory procedure, then the subsidiary legislation still valid. Okay. Example of case, you may refer to a case of agricultural, horticultural, etc. against Aylesbury Mushrooms Limited. In this case, okay, the court held that failure to hold a discussions with certain bodies before making an order was not according to the appropriate procedure. Hence, the decision made by the administrative body was void. This is the example of a procedure, mandatory procedure laid down by the Parent Act in this case. Okay, so when they fail to follow the procedure to hold a discussions, then the decision made by administrative body considered as void. Okay. So, at the end, we need to determine whether the procedure is mandatory or directory. Mandatory procedure is normally mentioned in the Parent Act, but not for directory procedure. Okay, so that's all the grounds that you must identify if you need to if you want to challenge the decisions or the legislation made by the public authority. So if you have any question regarding the lectures, please PM me as soon as possible. Thank you everyone. Assalamualaikum.